Welcome everybody. My name is Steve Johnson. I'm a freelance welfare rights trainer and I work for Child Poverty Action Group. And I'm here today to talk to you about a subject called complex needs within universal credit. I'm going to start that up now. There's going to be a PowerPoint presentation which I'm going to present to you. And as we go along, if anyone's got any questions, please say, and we can add you and we can go along that way. Any questions I can't answer, there are ways I can get back to you sort of later on. So I'm going to start up the presentation now. So if you kind of bear with me for a second, I'll call that up and then we'll kind of get cracking. So you should be seeing any second, hopefully, the presentation come up. This is, I'm just going to take it back to the first slide. It says Complex Needs and Universal Credit, St Martin's Frontline Network Conference. Like I say, I'm Steve Johnson and I'll be talking to you throughout this session. Please don't forget to ask me any questions as we go along. That's perfectly fine. I'll keep a copy of the participants in the corner so I can see that in case people come later. My colleague Joe will sort that out for me. So that's what we're going to be talking about. The subject is complex needs. The issue is around universal credit. I'm moving on to the second slide now, which is slide 2, to let you know what the agenda is. You'll notice some of the words are in blue for no particular order, just for emphasis really. So that's how that will work. We're going to start by talking for a little while about what I mean by complex needs, or rather what the Department for Work and Pensions means by complex needs. We're going to see how that works, what it means, and what the implications are for people. Then we're going to talk within the context of complex needs about a problem within universal credit, and that's the problem of claim closure. It's a problem because complex needs is about people who are vulnerable, and some people are having their claims for universal credit prematurely closed and possibly quite illegally closed. So I need to sort of talk to you a little bit about that. Then we're going to talk about how conditionality, universal credit conditionality, should fit around complex needs or vice versa. Then we'll talk about the position of universal credit in relation to sanctions and punishments. We'll do that, and then we'll keep going to section 5 and talk about whether it's a good idea or not for your clients who may or may not have been designated as having complex needs. That's kind of irrelevant, but whether they should jump ship from the old legacy benefit system, the benefit system that universal credit is replacing, and whether they should jump ship onto universal credit. I want to chat to you about that for a little while. And then to finish off, if you haven't quite lost the will to live, to talk about how you can propose complex needs status on behalf of your clients, people you're helping, people you're advising. That's really what I've got planned for you. I hope that's okay. If anyone's got a question they want to raise, they can just speak and Zoom will probably find you. You can go through the participants icon if you like and raise a question that way, but that's the way you'll talk to me if you want to talk to me. If you want to sit there and just let it happen, that's absolutely fine as well, whichever way you want to work. So that's slide 2. To start off with, slide 3, just to give it a tiny bit of context as to what's been going on in relation to universal credit and COVID. That slide there just summarises some of the recent changes that have been introduced because of COVID, going back to the beginning of lockdown 1. You'll be aware that the universal credit personal allowances were increased by around £1,000 per annum, and that was extended earlier this year by another 6 months. So we're talking about assessment periods ending around the 6th of October within universal credit before you can expect people's personal allowances to drop by something like about 86 quid a month. And that will happen automatically. We don't really know whether how much notice people will be given of that, but that's something obviously clients will need to watch out for. They can expect these drops. The £86 will be per claim, so it'll be the same whether you're part of a couple And just as a sideline to that, you're probably aware that instead of changing the rules for working tax credit, they're dealing with that for the first 6 months of this year by £500 payment. So looking at that list a little bit further down, you'll be aware also that universal credit conditionality was halted. The rules applying it were halted for the first 3 months of lockdown 1. That's actually relevant to people with complex needs. I'll be talking a bit more about that later, because the regulations that did that work finished, and then we're all left waiting to see what happened, and I'll explain that. Work capability assessments were to be done by phone or paper for obvious reasons, because of risks of infection. And in the last couple of days, the government's announced that these are all coming back face-to-face. Face-to-face contacts at the job centre, and face-to-face health professional assessments as well. Again, if people who have complex needs may be worried or concerned about that, especially since we're not at full vaccination yet, but that's a kind of a problem that we're all concerned about, because the government seems to be very keen, if not to forget COVID, but just to put it to one side in terms of the resumption of business. And that obviously is a matter of concern. Next down, the minimum income threshold was suspended because of COVID. That's really aimed at self-employed people. That change will carry on till the end of July this year. It's not specifically aimed at people with complex needs, just naming it really, and the government intends to bring back this minimum income floor threshold reduction system on a phased basis from August this year. A connected rule around surplus earnings is also due to extend until April 2022. That's not really about complex needs specifically either, although it could apply. But the final one very much is, and that's around managed migration. As you might remember, the government began to tinker with managed migration a while ago. It's centering on 10,000 claims in Harrogate. It sounds a little bit like a Beatles lyric, but anyway, that was suspended because of COVID, and we're all kind of waiting to see when that starts again. So that's kind of just a summary, a very brief summary there of what some of the COVID-driven changes. If any of you are particularly interested in the impact of COVID and on universal credit, there is a House of Commons briefing paper that you might be interested in subscribing to. It's called House of Commons Briefing Paper 8973. You may have seen it, you may have a copy already, it may be adorning your coffee table, but assuming that it's not, it's a rather long document, but it does contain boxes with information on it. I've given you a couple of screenshots here of some of the changes being flagged up. Some of them are COVID related, some are not. You can see the first one there on slide 4 is flagging up the extra money, what we loosely referred to as COVID uplift money, that's being paid, that £1,000 per annum. You can see it flagged up there. There's a link which you can actually use to hit the regulation which delivers it, and then there it says expected withdrawal dates. That tells you when it's expected to withdraw, and it summarises there the impact of this year's budget. Further down on that slide, I've just clipped out another example from a screenshot, and that's about the suspension of conditionality in universal credit and new job seekers allowance. I'll be referring to that specifically a bit later on. So that's all really in terms of just a very brief summary of some of the COVID related changes. I thought we'd probably better start with that, as we sort of carry on to 12:30 today. So that's that slide. We're going to move on now to begin to talk about what I mean by complex needs and what the potential impacts for your client group are. So if we move along to slide 6, a tiny bit of history, I suppose. Complex needs is a relatively new construct devised for universal credit. In the old days, if you were dealing with people who were complex needs is about vulnerability, and the government doesn't like vulnerable, to use that word too much. it prefers complex needs, and the predecessor term before that was safeguarding. Some of you might remember, if your memory goes back to about 20 years, there were some problems with employment and support allowance, in particular ESA, a sickness benefit. There was a lot of publicity, there were some suicides, and people were being named in suicide letters. ESA was being named as or problems with it as a contributory factor to people's suicides and self-harm. And the government of the day decided to bring in a safeguarding procedure, which essentially meant monitoring people who were thought to be vulnerable. And it boiled down to, if the department decided that you were vulnerable and had safeguarding needs, then they would undertake to visit you. Home visiting was the answer. And in fact, home visiting remains a central part of complex needs. Safeguarding was the term, it was linked to employment and support allowance, and it was carried on that way. Then universal credit came along. And for reasons that aren't entirely clear, the government at the time decided to drop safeguarding as a term to describe vulnerable claimants and replaced it with complex needs, as I will explain to you as we go along. So the idea was that if you were experiencing difficult life events or circumstances, then you may have complex needs, and that might mean that you needed more time to do things, more help to make computer-based claims, more forgiveness when it came to conditionality deadlines, and more forgiveness when it came to decisions as to whether to sanction you, etc. These are just some examples. And before too long, the DWP came up with some documents to help try and explain what complex needs would mean. And I'm going to be referring to some of their lead documents later on. There's the thing called the Complex Needs Overview, which the government have produced, which I've got a copy for you. As we talk, you will have access through this session to an e-learning handout, and one of the documents in it, the first one, is a copy of that most recent briefing paper I mentioned, 8973, the House of Commons one. But the second document, document B for Bertie, is a document called Documents for Vulnerable People, which I'll refer to later, and that does contain within it a copy of the latest Complex Needs Overview document, which I'll refer to later. I'll show you some clips from in a minute. Anyway, the government decided, or rather the Department for Work and Pensions decided, that we needed to have a concept of complex needs. And when you see the document, you'll see what I mean. It's really a description of people's needs by bullet point. So the document's about 4 pages long from memory, and it lists through bullet point after bullet point the kinds of people who may have complex needs. And that's really what it is. It doesn't, as you're going to find out, the document, although on the plus side, I suppose, it does describe a whole range of people who have complex needs. I don't think the document is intended to be exclusive. I think that these are examples that are bullet pointed. But as you're going to see as we go along, the Complex Needs Overview document produced for the DWP does not then generate any solutions. It doesn't tell you what you can get in exchange for it. So you can see that as a negative, I guess. So that's where the kind of term came from. So for a long time, safeguarding went because of when universal credit came along. Although it still existed, it was an ESA type feature. But then very briefly, very recently rather, safeguarding's come back, because out of nowhere, as I'll show you as we go along, the government have produced a separate stream of documents which refer to things like safeguarding. I don't know where this is all coming from. There's been some media discussions about it, but I will refer to it and try and give it some context as we go along. Like I say, if anyone's got any questions or points they want to raise, do say as we go along, and just call out. I'll very happily take any messages like that. You will get a copy of these. Someone's asking me if you will get a copy of slides at the end. Yes, you will. And the other thing I should have said, I guess, was that if you say anything and you want me to, I need to amend the slides just slightly to bring them bang up to date in the feature, I'll make sure that you get the very latest version of the slides. So as after the end of this session, I can assure you will get the very latest copy of the slides. And if there's not been amended, I'll just tell you. So that's that slide there. Before I come back to this whole business of the documentation that sits behind the idea of complex needs, I wanted to just chat to you for a while about what the government's view on all this is. The government have created a complex needs overview document and other documents. I'll be referring later to some sections from their ADM guidance, that's Advice for Decision Makers guidance, that talks about people with complex needs, and I'll be talking about that separately later. The government have produced then quite a lot of information about what they mean by complex needs. None of it's in regulation. It's important to make that point to you straight away. You won't, if you were to get a set of the Universal Credit Regulations, or even the Welfare Reform Act for that matter, and you typed into it complex needs and you ran it as a search, you'll find no references. There are no references in the rules or the regulations to complex needs. What we have is a lot of guidance and discretion, which that is something that some people are very unhappy with. But again, more about that later. I wanted to turn our attention now on slide 7 to talk about the duty of care, because if the Department for Work and Pensions have produced a complex, or it's been produced for them, a complex needs document, then that does suggest that a recognition of vulnerability, well, at least it does to me. But sadly, this idea of whether there is therefore a duty of care to vulnerable clients is something the government will not admit to. I wanted to raise Kofi in now, who's our Secretary of State for Work and Pensions, who made a statement back last year, that was from September 2020, and it's a quote from Therese. She says, I felt that the line of questions submitted by the committee was taking us down a track that implied that we had a duty of care, a statutory duty, and that's why I was being careful in trying to point out that we do not. I do not think it is the responsibility of the DWP to have that statutory duty. We are not the local council, social services, doctors, or other people who have. So it would appear as though what the Minister is saying is that there is no duty of care to vulnerable people, despite the fact that government is willing to recognise that they are vulnerable. It would seem as though that from the Minister's point of view, or the Government Secretary of State's point of view rather, that there is no duty of care. It's really down to other people. That includes charities, and I suppose that includes St Martin's and other charities, Citizens Advice and all the rest. So it would appear as though that's a kind of a view which the government have taken. Now, that's all really on that. What I can suggest to you, though, is that I think that's wrong. If we go on to slide 8, is there a duty of care? Well, despite what the Secretary of State is suggesting, I would suggest that there is very much a duty of care. This comes via the law, I would suggest. Certainly, there are clear legal standards of fairness wired into the Welfare Reform Act, which talks about reasonable steps, reasonable behaviour. Whenever you hear or read reasonable behaviour or reasonable action, that does imply a duty of care, a standard of fairness. We know this because certainly in the upper tribunal, we see endless cases where the courts or the judges have held that the department may not be acting reasonably in relation to these kinds of duties. So I would say there are standards of fairness. The Equalities Act, which I don't think has really got itself going as far as social security is concerned, clearly there are duties of care and fairness in that. And even within the complex needs processes, although they're discretionary, do suggest fairness and duties towards people to ensure that people are held up and are supported. That to me suggests an enforceable action. We all know, I think, that discretion, even if it's only described in journals or not in journals, in policy language, is enforceable through judicial review. So whichever way you want to really look at that, I would suggest that the Secretary of State is indeed wrong on it when she says things like that. I think it's very risky to make those statements. If we go on to slide 9, I wanted to return to this business of what complex needs is. And there is the document called the Complex Needs Overview. And I've just given you one or two screenshots from it. This screenshot is from the Complex Needs Overview. Do you notice at the top there on the banner there, on slide 9, it says V16, this is version 16, and you can go and see that. Now, the document, if you want to see the document, I'll just go to the next slide for a moment. I'll return back to slide 9 in a moment. You've got a set of documents called Document A in your e-learning pack, which comes with this discussion. I've called it the documents for vulnerable people, documents relating to vulnerable people, and I've composed it, I've put it together for you, and you'll see there are some clips from the Welfare Reform Act and the current regulations, and those clips that I put together for you do include key clauses which repeatedly use phrases like reasonable action, and that to me suggests a duty of care, as I discussed earlier. I've also attached for you a natural migration checklist that comes up later in our discussions, and if you go down there, you'll see on page 23 of that document, which you've either got or you will be receiving, is a copy of the DWP's Complex Needs Overview, and you'll see it's only for a couple of pages long, and that's a document. If you want to see it, all you've got to do is to go to Document A in your e-learning pack and just go to page 23 of it, and there it is. So that's where you'll find it. Otherwise, you can search for it and find it in a different way, and I'll tell you how to got some guidance in just a moment. But going back to the Complex Needs Overview, it's really a mission by bullet point, and I've just clipped out a little part of it here. You can see here that it talks about people having complex needs if their current circumstances present particular challenges. That's the kind of phrase that they use. The particular challenges are listed in these bullet points, and someone's asking me how you get access to the documents for vulnerable people pack. It's part of the pack that was been prepared for St Martin's. If you contact St Martin's, I'm sure they'll send you those documents in a bundle for you. So if you think about what the Complex Needs Overview does, it talks about people having particular challenges, and then it talks, a lot of these documents produced by the DWP constantly go on about people's journeys. This is about the journey that someone made, their customer journey. Must be equal in quality and outcome. I suppose that's one way of describing what this document is supposed to provide. Although, like I say, when you look at the document, what you won't see is a detailed description of what you get if you've got complex needs. So what you do in fact have are a long list of bullet points setting out who may have complex needs. It will include people who've got physical or mental health problems. It will include people with literacy difficulties, etc. All the usual, as someone said, all the usual suspects. But I'm not sure what they mean by that, but it won't tell you what you can expect in return for that status. And I think that's a particular problem, because it's one thing to persuade the DWP that your client has complex needs, but what happens then? And that's, I've got a suggestion for you for that, which I will come back to later on. Now, that comes at the end. Now, in relation to finding this stuff, I've told you that in your e-learning pack, I've included a copy of the complex needs overview for you. But if you wanted to see what's on offer generally from the Department for Work and Pensions, it's worth bearing in mind that there are two main sources of guidance that the Department for Work and Pensions produces. The first main source is what's called the ADM guidance, Advice for Decision Makers guidance. And if you were to type into Google or whatever your browser thing is, Advice for Decision Makers, guidance, universal credit, what will then come up is a long list, and you just click and screen and scroll down, and you'll come to a range of documents. In your e-learning pack, there are two chapters which might be interest to you, ADM chapters. One's called J3 and one's called K2. And we've put copies of those chapters in your e-learning pack, just in case you wanted to see them. So that stuff comes from the government's strategic ADM guidance. The other form of or stream of guidance that's available to you is the internal, or it's not internal with you, or what I should say is the operational guidance produced by the Department for Work and Pensions. Now, that's a bit more difficult to find. If you typed in operational guidance universal credit, it probably won't come up. But if you wanted to find it, it's been archived, RightsNet has archived this for us, and we can, if you were to type into Google RightsNet, universal credit operational guidance, bit of a mouthful, that will come up as a link right at the top. And if you click on that, you'll then get a list of the operational guidance documents, which are shorter and more kind of day-to-day. I think it's the best way of putting it. And you can click on those. Now, if you were to go to that and scroll down, then you will come across the complex needs overview document. So that's where you would find it. So I took that from the operational guidance and I've stuck it into the documents for vulnerable people pack that I referred to later. So those are the two strict kinds of documents. Now, talking about the ADM guidance, the strategic guidance, if you were to go to chapter J3 of it, it's quite good. It talks about what happens if you have complex needs in relation to things like your conditionality and how that should interplay with the requirements that are put on you. So chapter 3 is worth reading. It's reliably short. It's not an all-day read, as is chapter K2. I've put both in. K2 is more about punishments, which I'll talk about later. But chapter J3 is about complex needs in relation to difficult events. Now, I've just done a screenshot here on slide 11 to give you a flavour of how this works. If you were to read it, this is written on behalf of the Department for Work and Pensions, talking to decision makers and work coaches, talking about complex needs. If you were to read it, as you can see, it says complex needs means a claimant is experiencing some difficult life event or circumstance. And then it goes on to list some. These are not an inclusive list, they're an exclusive list, but it says here, look at number 1, it says a sudden illness. Do you look at number 3, it says temporary homelessness. I don't know whether you get the swing of this, but to me, the philosophy behind this is that your crisis, your vulnerability, is necessarily temporary. I think this is political. I think the government wants to see people's problems as being temporary and all solvable. There's a kind of a seam of optimism running through all of this, which I do believe is misplaced, because some of your clients will have long-term or possibly permanent substance or alcohol problems, or may have mental health issues which may or may not be short-term or long-term. But I think that the government is quite keen, when it categorises you as having complex needs, to see that as a temporary issue. This will be revealed further in our discussion today, when we talk about other steps the government's taking in relation to complex needs. I will come back to that later on. So the first point of this then is that complex needs exists as a policy, it's discretionary. It sits in both the operational guidance, which is the complex needs overview, and it also sits within the strategic advice for decision makers, or ADM guidance. So you can find it there. You can find lots of references to it. And I think it would be a good thing for you, if you are working with clients who are vulnerable, to keep abreast of this guidance and to quote it. It'd be good to imagine you quoting this guidance back to officers at the job centre if your client's getting the runaround or is being treated unfairly. And I would also suggest that if you are dealing with appeals to tribunals in relation to someone who's vulnerable, then clearly your knowledge of the regulations and the case law will be very important. But equally important is your knowledge of the guidance, because I certainly find in dealing with judges at tribunals that if I can quote to a judge guidance that is there but has been ignored, that almost automatically wires in sympathy from the court to the points that you're making, and as it should do, of course. So let's not forget that the guidance is there. I know it's not the law, but it is. But we do also know that if reasonable guidance is being ignored, that could be something that could be dealt with via judicial review ultimately. And so that our judges know this. So it's worth citing when we're trying to take on the DWP, if that's the right phrase, if we're trying to discuss things with the DWP. So that's a short outline of the immediate documents that are available from the Department for Work and Pensions. I said earlier on that safeguarding has come back, and it has come back. Out of the blue, the government's come up with a safeguarding policy. It wasn't there a little while ago, it is there now. And I knew you want a copy of that, so I've put a copy of this in your e-learning pack. It's document C, and it's version 3. And I've given you some clips from the safeguarding policy. And so we've now got complex needs, and we've now got safeguarding. And safeguarding is a particular aspect of complex needs. And if you look at it, I thought I'd give you some clips here on slide 12 about why is safeguarding different to complex needs. Well, I think it's all about where there is steps that need to be taken to protect your health or well-being. That says to me it's returning, in my mind anyway, to this business about risks of suicide or self-harm. Seems to me there is the ring of this from the old ESA days. And when it talks about additional needs that may be there, if you look on that clip there on slide 12, we've got some familiar phrases that came up earlier on under complex needs. It's talking about mental health, homelessness, domestic abuse, addictions, etc. And so safeguarding has been brought in. It's not here to contradict complex needs. I suspect it's here to focus on particular groups of vulnerable people. So it might be of an advantage to have your client described as having complex needs, because I think that's a status that your client should have. I think it's something that is good for your clients to have that status, because it should make life easier for them. I do recognise that some people won't want that stigma, won't want that title on them, but it could be a status to have that could be useful to you. And whether you feel the same way about being labelled as needing safeguarding, of course, is something you need to think about and talk to your clients about. But having these kind of labels can be useful in relation to, I think, what we get from the DWP, assuming that we articulate these labels properly. And I'm going to, like I say, I'm going to finish on that later on. So safeguarding then is another concept that's being used, that's followed on from complex needs. When we kind of think about how all this gets expressed by the DWP to clients, if you think about the screens that are used for universal credit claims. Many of your clients, I imagine, who've made claims for universal credit will have made online claims, although some of your clients will be making claims over the phone because they can't use computers or don't have them available, etc., etc. But certainly, if you think about, for the time being, you think about people who've made online claims, and you think about, well, what is on the screens that tells us the client's got complex needs? What's on the screens telling the client that they need safeguarding? And you'll find there's very little. Instead, what you will find is this. You'll find a system of pinned notes. I don't know whether anyone in the audience has come across this phrase, pinned notes, but this is something that's been developed by the DWP. And the idea of it is that the pinned note, certainly from the point of view of online claims for universal credit, are kind of electrically pinned to the computer. And on the pinned note will be references to the fact that you are vulnerable. And this may be because you need safeguarding or otherwise. And the idea of it is that this pinned note won't scroll away into and won't disappear. It's kind of, it'll be constantly in your sight. The worry about a pinned note is the very idea that it's a pinned note. Because if you think about, forgive the picture, that's on slide 14. If you think about a pinned note, that necessarily makes you think of a little message stuck on a filing cabinet or maybe even a computer screen that eventually falls down, probably down the back of the filing cabinet, and is never seen again. It doesn't really inspire very much faith in what's on it. The pinned note, as it's discussed, does not seem to have a structure. We don't know how long the pinned note will be pinned, and I certainly can't. It's difficult to know how easily that's shared. Certainly, the pinned note should be available to anyone who looks at your client's claim, because the pinned note should be there to give information to anyone who views it. So I guess we kind of know that much. Along the line, earlier this year, the government came out with some more information on how all this works. And there was something called Spotlight was released. Spotlight is, as far as I can see, is some kind of a device where important information is passed to DWP officers. It's a bit like a memo, but it's a memo, a particular angled memo. It's called Spotlight, and you'll see Spotlight referred to quite a lot in various documents and discussions. And this, I'm showing you this on slide 15 now, because a Spotlight document was released, and it referred to the client profile of a client, and it began to refer to what might be on the pinned note. And it says pinned notes are a record of someone's needs. It's an overview of the problems. It can be tailored. It should be kept up to date. It should be available to officers to read. This is the kind of introductory stuff they were talking about when they're advising how officers should use information about vulnerability. The Spotlight this Spotlight document, and by the way, I've given you a copy of this document. It's document D in your e-learning pack. If you were to look at it, it goes on to talk about pinned notes. And it says that these are an important function. It reduces the need for officers to scroll down and scroll down and scroll down to look through your file, because the pinned note is kind of electronically always in your vision. And it's there to highlight the claimant's complex needs. So it would seem as though these pinned notes are about complex needs, and I imagine could also include material about safeguarding if there's a particular angle or relevance to that. So the way it should work then is that the DWP officer would look at the material from their end, and they would look at the pinned note. Then the spotlight goes on to talk about other tabs that are available. If you look further down on that screen, it talks about the history tab and the recent history tab. I don't know whether any of you have seen these tabs. They're not. I've not seen them as available to clients I've dealt with. I'm suspecting that these tabs are only available to the DWP officers looking at the computer from their end. So Mark asked me, can you add an entry on the journal stating the client has complex needs? Yes, you can, Mark. I'm suggesting that you don't do that though. I'm suggesting you do it my way, which is to attach a formal complex needs request, status request. I'm going to give you a pro forma for that later. I'm keeping that till the end to keep your interest, hoping that that will be something useful. But yes, if you didn't want to do that, you could certainly write on the journal a statement to assert the client's got complex needs. And the cool thing about doing that is that it's a permanent record. And again, you could raise it later if you had a problem at an appeal, especially if it appears as though the DWP that's taken no action in relation to the complex needs that you've pleaded for the client. The final thing to look at on this slide before we move on is the paragraph right at the bottom there, which says that every pinned note should be pinned to a total of 3. I don't know what that means. I don't know whether it means you're only allowed to have 3 crises at once or 3 issues at once. I would suspect that's what it means. 3 history records or 3 references. Why they've chosen 3, I don't know. You may well have clients with 4 or 5 issues. Some of them might be physical and or mental health related. So there's a concern about that, isn't it? That if it's the case that we're being restricted to a certain amount of information. Of course, without being cynical about this, and you can tell that I'm not a cynical person, we know when we look at claims for employment and support allowance or sick status, or very much when we look at PIP, that there's an awful lot of management goes into trying to reduce the amount of information or targeted information that would suggest an entitlement to either ESA or UC or PIP. That's very much, in my view, within the culture of the DWP to try and manage information flow so that not too much information is given. I suppose I'd get in trouble for saying that if the DWP were watching, but I could happily engage with anyone to talk about how relevant the PIP2 form is, or the ESA 50 for that matter. If anyone wants to do that, I'd be up for it. Anyhow, moving away from that, that's just back on slide 16. That's the Spotlight claimant profile document that I've referred to, and that you've got a copy of in your e-learning pack. Before we move on, I thought it might be useful just to recap on these phrases, because it's very easy in all of this to get completely lost in all the phrases and concepts that are being thrown around. Complex needs has been with us from the beginning, really. That's a status. I've explained what that is and how you see the document. Safeguarding has been brought in recently, but it's particularly angled at people with health and well-being issues or threats. The government has also talked recently about people who need advanced support. So advanced support seems to sit all on its own, but it's when you read about what advanced support means, it's often referred to as specialised help when there's safety or well-being threats. So I guess advanced support kind of connects to safeguarding. And then we've got this kind of claimant profile document, which is also in your e-handout, which talks about the PIN notes. And PIN notes are associated with complex needs, stroke safeguarding. So those are the 4 kind of concepts, I suppose, or ideas that I've got. There may be others for all I know, but these are the 4 immediate ones for you to be aware of as we move on into the subject matter. Only got about 45 minutes to go. I thought I'd just let you know that. The next issue to talk about is this business of claim closure. And this is a problem because we're finding that people are claiming universal credit and then having their claims closed. And they're being closed prematurely. And the reason I put this on the agenda is a worry that this is happening to people who are vulnerable, because it's tending to happen to people who don't jump quick enough, people who don't respond quick enough to instructions from the job centre. To give us a little bit of context, when you make a claim for universal credit and you submit claim, you'll get access to your journal. And then at the end of that section, you'll be invited to book appointments. Now, at the moment, they're being done over the phone because of COVID, although that is now, we're told that's changing very shortly. But you'll be asked to attend a number of appointments. Now, I've listed on this slide here the kind of nature of these appointments you might be asked to attend. It won't be all of them. It will depend on your claim. And I do recognise that the name of these interviews will change from time to time. But I've listed the main ones here for you. Do you notice some of them are in green? I'm calling them, the DWP doesn't call them green, I call them green. And these appointments, I'm calling them green because they're appointments about evidence or information that's being required. So you might be called in for an appointment to discuss your ID. That can be a particular problem for some people. You may be called in for an appointment about your immigration status or evidence to support your claim. Often rent issues come under these headings. Now, these are information or evidence appointments. Now, I've called those green. There are blue ones. Now, the blue ones are more serious in a way. I've called these are blue because they're about conditionality. These are interviews about whether to probe information to decide your claimant commitment or to offer it to you for your signature or acceptance, etc. So interviews for work-focused interviews, which are the main driver of sanctions, are blue ones because they're all about you obeying the requirements of your conditionality. The green ones are evidence or information interviews. The blue ones are about your claimant commitment. Now, the reason I'm calling them green or blue is because the government doesn't seem to understand the law. The green interviews, the evidence or information interviews, do not even require you go to an interview. They require that you submit information or evidence within a month. There's a regulation that does that. That's regulation 37 of the claims and payments regulations. So what we're finding is some people are being closed down, their claims are being closed down within a couple of days of not responding to an instruction to attend a green interview or an information or evidence interview. And that is simply improper and incorrect and unlawful in a sense, because I'm going to show you some case law later that proves that. But it's happening, and I want you to know that so that you feel strong enough as advisors to challenge inappropriate threats or actualised closures or terminations when the law's not being followed. More of that later. On the blue interview side, it's much more worrying if you do not respond quickly to a blue instruction, to a blue interview requirement, because that's about your claimant commitment, and that's at the heart of your entitlement to UC. The Welfare Reform Act is involved in this, and it says that if you don't agree a claimant commitment, you're not entitled to UC. And that gives much more power to the DWP to act quickly. So we need to distinguish between the green and the blue. We know it's a problem. Maybe 1 in 5 people who claim universal credit are having their claims closed, possibly prematurely, maybe up to 20%. That's a very high number. And if that includes your vulnerable clients, then we certainly need to know what we can do about that. So the first thing you would do if a client's been threatened with claim closure is to check out whether the client is failing or has been asked to attend a green interview or a blue one. If they've already had their claim closed, that's far more difficult because according to the DWP, you can't wake it up. All you can then do is reclaim and then presumably enter an appeal about the closure of the earlier refusal or declined award on the journal of your new claim. That's very messy. It's much better if we can intervene before the client finds their claim's been closed down. Once it is closed down, the journal's still there, the claim is still there, but you can't interact with it, and it might as well be dead. You won't be paid. So it's quite a serious matter to have your claim closed. Now, what does the case law have to say about this? I'd like to take your attention to a decision called PP versus Secretary of State for Work and Pensions. There's a copy of PP in your e-handout because it's a good decision to read, because it talks about what powers the department actually has. If you were to read what PP says, it says there's nothing in the claims and payments regulations, by the way, that's a reference to the green interviews, that makes attending an interview, in this case about self-employment, a part of the claim process. In other words, the judge in this case is distinguishing between making a valid claim and the non-attendance at an interview. They're separate matters. The judge goes on in paragraph 40 to say, a claim for universal credit is, in the prescribed manner, is made before the question of, in this case, self-employment is fully explored. In effect, the request the claimants arrange and attend an interview is no more nor less than a demand for information or evidence under Regulation 37. Do you see that? That the judge is saying making a claim is very different to you turning up for an information appointment. And not turning up for an information appointment, therefore, should not in itself lead to the termination of your award. If the DWP invites you to attend a DWP information interview and then you fail to do it, notice the law says you've got a month to comply with any information request. Well, that would mean surely that having failed to attend an interview or given information, they'd have to wait a month and then make a decision when to close you down and then notify you. And this is not what's happening. And this is where I'm hoping that you're willing to engage with that and to challenge the DWP. To do that, you've got to know the law, and you've particularly got to know what the case law is saying. I'm willing to bet you a Kit Kat right now that 95% of your decision makers at the DWP stroke work coaches have never heard of PP. And it'll be news to them to know that they don't have the power to shut people down in this way. But it's obviously important that you know that so that you can act on a client's behalf. If you like, you could think about judicial review. On CPAG's website is a suite of pre-action letters they're called pre-action letters. They're not threat letters, although some people call them threat letters. They're letters to send to the DWP to tell them that if they continue to abuse this legal position, they could be vulnerable to judicial review. This is because claim closure as a punishment strategy is unlawful. I'll leave it to you as to whether you're interested in using these kinds of letters, but go to CPAG's website. We find they're very effective. We find at CPAG that in 90% of cases, when we engage these kinds of letters, that we get change very quickly, much quicker than you'd get through an appeal. But that's just something for you to contemplate. If, on the other hand, your problem is not with a green interview, it's with a blue interview, if it's about a claimant commitment, a failure to attend a claimant commitment appointment, we must be more wary, because Section 4 of the Welfare Reform Act tells us that if you don't accept a claimant commitment, then you can lose entitlement entirely straight away. That would require a decision to terminate you and then a letter notified on the journal or by paper. But whichever it is, green or blue, you're certainly entitled to a termination letter before they turn you down. The problem is for green ones, you've got a month plus a letter. For a blue one, there isn't a month to wait. You've got to accept the claimant commitment promptly. I think we should encourage our clients to attend both green and blue interviews with equal enthusiasm, but it's the blue ones you need to watch out for in particular. The DWP actually has got a policy on claim closure, and it's in their operational guidance. There's a document called Claim Closure version 15, which I've put in your e-handout. It's document F for Fiona, and you can find it in your e-learning pack. You could also go to the web and download it for nothing. Now, I've left this screenshot on claim closure for you for a number of reasons. First of all, just to make the point to you that there is no such thing as claim closure. You can't close a claim down. You can only close an award down. I'm not trying to be pedantic, but I suspect that they're calling it claim closure at the DWP in an attempt to show that they're snuffing out something that's not really started. And that's improper and unlawful. You can't close a claim down. The claim is something the client does. It's not something the department can stop. What the department can do is terminate your award. And that's an entirely separate matter. And that carries with it rights of revision and appeal. That's the first point about that. The second point about that is this bullet point list you've got here, which talks about circumstances where a client might find their claim's been closed. Please look at the first bullet point with me. Fails to book an evidence interview. That is not grounds to close an award. That can only happen after a month. Have a look further down. It talks about hasn't accepted a claimant commitment. That would be grounds to close you down, but only after you've received a letter notifying you that you've been terminated. If you look further down to the bottom, notice it says your client suffered a bereavement of the partner or a child. I'm highlighting this to you. How could the death of your child mean your claim should end? This is, I think, I would suggest to you, a very strange document. I don't know who's written it or what it's intended to do, but it's wrong in title and it's very questionable in substance. And whilst it's useful for you to know about, I think this paints a picture of us of possibly an organisation that's not really used to its power or its lack of power. And I think we need to be aware of that when we're trying to protect our vulnerable clients. Taking this kind of matter on, of course, is difficult. You need to know a bit about the law, and in your Documents for Vulnerable People pack, I've given you some clips from the regulations in the Welfare Reform Act that talk about things like conditionality. You also need to know about the guidance, and you also need to know about the case law. I've mentioned to you PP, which is a very good case for you to know about in relation to clients and claim closure. And what I'm trying to build up here is a library for you. It's not bullets to fire, maybe that's all a bit military, but to suggest strategies and knowledge of law which you can use to directly challenge poor practice. I should also say, of course, for clarity and for fairness, that there are some very good officers at the DWP who are very positive. But clearly clients don't queue up to tell me about how wonderful their day was at the job centre. They tell me about the problems. Anyway, moving on, slide 26, conditionality and complex needs. You may be wondering why there is a cart before a horse. This is to give you advisors a simple message you may already know very well, a simple message that the conditionality that you're set by your decision maker stroke work coach is at the discretion of the Department for Work and Pensions and is not something you can appeal about. Whereas if improper conditionality has been imposed on you, say because you're vulnerable, say you've got complex needs, you only then have a right of appeal if you fail and are sanctioned. That's why the cart is before the horse. The obligations set upon you do not carry a right of appeal. You only have a right of appeal if you fail, which a lot of people have criticised as being unfair, but I think that's where we are. It's certainly true to say that your requirements should match your ability. This is not something really that the Secretary of State has got a right to comment on, because there are notions of fairness within the regulations and the Welfare Reform Act. The Welfare Reform Act goes to some detail to say that when they set your conditionality, the conditionality set for you, and conditionality is actually not the word, the correct word is requirements. Conditionality is nothing but a list of requirements. The requirements that are being set for you have to reflect your ability to discharge them. That's what the law is very clear about. Now, you can dispute the conditionality. I wonder if any of you have ever tried to do that and got anywhere with it, something that which we do from time to time. But certainly, if you can't get your conditionality softened because your client is vulnerable, then remember that there is a right of appeal if you're sanctioned later. This picture, this slide 29 has got me into a fair bit of trouble with the DWP from time to time. The picture is a thing called a joke, and it's meant to give an image of a work coach lasering a claimant who's not obeyed their conditionality. This can be a bit of a problem. I don't wish to be aggressive to anybody. I just meant that as a little joke. It comes from a film called The Day the Earth Stood Still. You might know the film. It came out in 1955 from memory anyway. So the point I'm trying to make to you is all this depends on, when it comes down to conditionality, how fair or reasonable your work coach stroke decision maker is. And that's something that is very difficult to challenge. We're told in guidance that you can ask for a different work coach or decision maker if you fall out with the one that you have. I must say I've had very little success with that. You may have had success. I don't know. We're told you can get a second opinion on a claimant commitment. That's in their guidance, but it's not in the law. So whether they do that or not, nor is it in the law to give you 7 days notice if you want a cooling off period, although that is in the guidance. So it's probably worthwhile knowing about the guidance just for that. Certainly, if you believe that the conditionality that's being suggested or imposed on you is unfair or wrong, because your client's got complex needs, then it's perfectly possible to seek either easement or limitation. The law specifically allows you to seek easement of your conditionality on a temporary basis or on a long-term basis, a limitation. I'm highlighting in blue the words. It's probably right to use the right language. So you can seek easement or limitation. If you get it wrong, it doesn't make any difference. But I think it's probably good to use the right language when we're talking to the DWP. If we think about what the law has to say, we've got the Welfare Reform Act setting out these principles, but you've also got a range of regulations and these are in the main UC regulations, which set out what your conditionality is, but also wires into it forgiveness, if you like, or easement if you can't discharge something. So if you've got someone with complex needs, someone who's vulnerable, who can't do all the stuff that the government, that the job centre might want them to do, then the law says that should be discussed and taken into account before the conditionality is set. Regulations I'd like to specifically draw your attention to here are regulations 95 and 97, which talk very much about setting requirements, but also guaranteeing forgiveness or making adjustments to conditionality. So for example, if you've got a client with young children and you can't be available for work at 35 hours a week, that should come down to 20 or whatever it is. If you've got someone who's sick or disabled, then if you're subject to conditionality, that should be softened to recognise that. And that should certainly include people with mental health problems. If we're going to take the DWP on this, you're going to need the regulations at your side. So you've got something to say to the officers. I'm hoping that you would do that on an individual basis, but I'm also hoping that you might want to do that in liaison meetings with the job centre. As and when these things return, if you're working in an area with a job centre where the staff are not very sympathetic, it'll be very important to go down to the job centre and discuss with them to what extent your officers, their officers, are familiar with regulation 95, 97, etc. Why not offer them some training or support from your angle? When I used to work in citizens advice, we did that all the time. I think we've all got too busy now for a lot of that, but it's worth bearing in mind. The other thing you can do, like I say, is to try and take this matter on through pre-action letters. And there is the library you're looking at now that CPAG have produced. You may or may not fancy this. It might not be something your organisation is particularly keen on. Some organisations might see it as too aggressive a policy. I know the government's not very happy with all of this. The Ministry of Justice produced a statement recently speculating or wondering why so much of this action is going on. Is there some kind of background reason for it? I wonder whether they think we're some sort of kind of threat to democracy. I don't know, but I would certainly encourage you to think about these kind of protocol letters to focus back to where discretion should sit. But that again is something for you to think about maybe in the future. In relation to sanctions and punishments then, I'll talk a bit more about sanctions separately in a moment. I do think that if we've got a vulnerable client, someone who's got complex needs, I'm assuming those are your clients, then there is a heightened risk they will face sanctions and punishments. What officers tend to do is, because they don't have a lot of time, they see a client who's got a sanction coming, your automatic response will be to launch some kind of good reason defence to the sanction, which you might try and articulate through an appeal. That is what I call the level 4 action on that slide. I'm instead suggesting you need to use a checklist where 4 is the final thing that you do. Number 1, you need to check, has the person been correctly notified of their claimant commitment requirements? If they have been correctly notified, with sensitivity to literacy or maybe in terms of hearing or seeing or whatever else, has the conditionality been correctly set? Is it reasonable to your client's needs and problems? Assuming it's been correctly notified and assuming the conditionality is reasonable to your client's needs and problems, has there been a breach? That's level 3. Or has the client simply done the best they could on the day and maybe failed? But assuming the client has been correctly notified and that the conditionality is reasonable and that the client has failed, then and only then would I suggest that you think about a good reason defence. Mark asked, what if English is not someone's first language? I would say that's something that they should be definitely sensitive to. We've seen time and time again, certainly my clients who don't have English being pushed into jobs which, without a sensitivity to their ability to speak English, I would certainly argue that's a good reason defence. Assuming that I've had a case where a judge wasn't happy about the lack of vigour with which my client tried to learn English. That caused the problem, but it's certainly not outside what could be seen as complex needs. And I would encourage that. My point, going back to this slide, is that when we're looking for us to deal with a sanction, we must engage all 4 levels, and our write-up should reflect that in those investigations. We shouldn't just go to level 4 because we're busy. That's my suggestion. I next wanted just to refer to very briefly to a piece of case law, and this is an important decision called RR versus Secretary of State for Work and Pensions. This decision came out a little while ago, and this is a really good decision. It's in your e-learning pack, and you can use it as a sanction buster, but you can also use it, I would hope, to negotiate with the job centre to encourage conditionality limitation. RR versus Secretary of State, like I say, is a good decision. It concerns someone who had a work search requirement that, and he failed the requirement, he was sanctioned. It all ends up in the upper tribunal. And what the judge says in the case is paragraph 36, is that whilst it's true that you don't have a right of appeal about what requirements are set for you, if the requirements were set without regard to your personal circumstances, that constitutes an error of law. And that means that if you're sanctioned as a result of that, the sanction should melt away. So whilst you don't have a right to go to a tribunal to challenge the nature of your conditionality, the fact it wasn't properly discussed with you, you can use that to torpedo the sanction. And that, I would suggest, is a very good bit of case law for you to know about. In relation to sanctions, Chapter K2 of the Decision Makers Advice to Decision Makers Guidance is very useful. K2 talks about sanctions and complex needs, and it's very quotable. Some claimants may readily disclose complex needs. Other claimants may be unwilling to reveal they're experiencing difficult life events or personal circumstances. Well, crikey, those of you who know about Stoicism, those of you who know about dealing with PIP, will know that there's a stream of case law that addresses Stoicism and what the impacts can be and how that can lead to wrong adjudication. And this kind of Stoicism from claimants when it comes to revealing their problems can also make problems around sanctions and universal credit generally difficult. And I'm suggesting that K2 is another bit of guidance. It's very useful for you to have up your sleeve, because if a person's been sanctioned and Chapter K2 has not been followed, you can quote that and use it in your appeal submissions to tribunals. Here is some case law. This is universal credit case law. This is KB versus Secretary of State for Work and Pensions. This talks about what might constitute a good reasoned defence. And I've clipped out at the bottom there references to mental health. I know that some of your clients have mental health problems, and there's nothing wrong with emphasising when the case law is strong on our behalf. So that's a decision which you might want to download. I've not put it in part of your e-learning pack, but that is a downloadable decision. If you struggle with that and you want me to send you a link, I can do that. All you got to do is send me that message via St Martin's. Here's another decision which you might find useful. This is KB versus Secretary of State for Work and Pensions. This is also about sanctions and talks about failure to take into account a person's physical problems. In this case, a person's stomach ailment. A person was sanctioned as a result of non-performance, but there was ambiguity in the notification about the conditionality, and that generated grounds for a defence. So there are a few decisions like that. I only got about 15 minutes to go, so I thought, I know we're going at a fair pace here, but you will have the PowerPoint to reflect back on later. I wanted to move us on next to talk about the final important area, and that is whether to jump ship onto universal credit or not. This is all about whether your client should stick or twist. Should they stick on legacy benefits, or should they twist onto universal credit? And this is a problem which, surprisingly or otherwise, is becoming a big issue within universal credit, because there are several million people, we think, still stuck on legacy benefits who don't know whether to jump ship now or to wait until universal credit is eventually, if you like, imposed via managed migration. This discussion is all then about whether we should stay on legacy benefits or switch on to universal credit. I do hope you like that little picture. I wasn't sure it's a new one I'm using. I don't know whether it means anything or not. I just liked it, so that's the reason I've done it. But it's whether we should be saying goodbye to the old benefits and embracing the new ones or not. This turns out to be a difficult thing. We know there's been a rush of applications for universal credit. We're running at over 1 million claims a month at the beginning of lockdown 1, and that's now quietened down from 170,000 a month to 130,000 a month. But we've got about 6 million people on universal credit now, roughly the same number claiming PIP, as it turns out. We know that the rate was at 130,000, probably gone down a bit now. We know that it's gone to balance of about 50% male versus female. The government only categorises men and women in that kind of research. We know that about 20% of UC claimants are under 24. And we know that of the 40% of people claiming UC as work searchers, nearly 90% of that group have got no work at all. Another 40% are working or are on low earnings. And all this data is available if you wanted to see it on websites that you can kind of subscribe to if you wanted to. So whilst it's looking that there's a lot of people claiming universal credit, a report done by the Welfare at Social Distance report, which came out a couple of months ago, tells us that there are a remarkable number of people who are coy about claiming UC. The report speculates there could be over 200,000 people who could make a claim for UC, who know they're eligible but are just not doing it. And maybe another 300 to 400,000 people who wrongly believe they're not entitled. Something's going on where a lot of people are refusing to claim or don't know that they're entitled and are not claiming. Many of these are under financial strain, etc. These are likely to be many of your clients. So should people jump ship or not? Is it a good thing to do? In order to help that discussion, I wanted to spend a minute or two talking about the Severe Disability Premium Gateway, because this is the SDP Gateway regulation was a regulation that was brought in back in 2019 and ended back in January 2021. And the regulation was brought in because a number of disabled people on legacy benefits had jumped ship onto universal credit and ended up much worse off. They went to the High Court and they won. The government dealt with that by introducing SDP gateway regulations that were supposed to be there to prevent people from claiming UC, universal credit, if you were a disabled person living alone without anyone getting carers allowance, etc. That was the idea. That regulation was brought in but then revoked really just a couple of weeks ago. And there's the revocation regulation you can see, operative since the end of January this year. Since that regulation has been revoked, what that means is that anyone can now claim universal credit, whether they're disabled or not. There's nothing stopping them doing it. And that introduces considerable worries and concerns. The DWP have produced a memo. It's memo ADM 0121. It's the DWP's official guidance on all of this. And I've put a copy of that in you. That's item K in your e-learning handout, in case you want to read it. There's a lot of false publicity going on about this, not in that memo particularly, but there's a lot of people at job centres being told now that they should be claiming universal credit and possibly riding on the back of the revocation of that regulation. But let's be clear about this. The revocation does not require you to claim UC. It does not require you to claim UC simply because you've had a change of circumstances. And there's nothing in the revocation that prevents you from expanding the legacy benefits that you've already got. So there are very, very big issues with this. What's happening is that I'm coming across a stream of clients being told that they must move over now because of the revocation. And that is simply unlawful and wrong. At CPAG, we've just devised a training course on this very issue. We're giving it 3 hours all on its own. It's called Stick or Twist. I suppose I'm advertising it now, but we're trying to get advisors to think very carefully about whether they should stay where they are or should jump ship. Now, time's against us, but I've left in your slides some discussion on this. It's certainly possible, it's certainly true to say that in most cases you can't make new legacy claims anymore. You can for housing benefit if you're in specified in temporary accommodation, but the point of the revocation is that you can still expand what you've got. The important thing is for you to know what legacy benefits your clients are actually claiming and in whose name they're claiming them. And nothing prevents you expanding them. So your clients could be on legacy benefits now, become disabled next year, get PIP, and then be entitled to additions in their legacy benefits. And even then, if they transferred to universal credit, get some compensation because of that. So it's very important for clients to remember, nothing stops you growing what you've got. The problem is knowing that you can't make new claims. I've left in your slides some information about how all this works. I've left slides to tell you about who's eligible for the compensation. Again, time's against us, but I've also left you information about the timing. If you're going to move from legacy benefits onto universal credit, if you're going to do that, then you want to make sure that you're entitled to what's called severe disability premium, that you've got it bedded in before you jump ship. And you really need a week being entitled to SDP in legacy before you jump ship. Watch out for that. It's important. Depending on the timing of appeals, you may be able to rescue money in this way, but that's something that you just need to be aware of. Timing is important. Sorry, I jumped ship. I jumped some slides there. I've left some information there about how much money you may be entitled to. These are fixed amounts. At the same time as revoking the gateway regulation, they introduced transitional severe disability premium element, which is a form of compensation that adds to your maximum amount for universal credit. Do you see that the amounts that you get are fixed at the outset? 120 or higher, depending on whether you're single and depending on how sick you are. But notice that those amounts, although they're added to your maximum amount for universal credit, they are subject to erosion and reduction. And this has been done, I'm afraid, intentionally. Your compensation, if you want to call it that, can be reduced as time goes by. For example, your compensation could be reduced if in the meantime a new baby is born, which increases your universal credit a maximum amount. That can eat into the amount of transitional protection that you get. It won't happen in childcare when childcare increases, but it's the system's designed to erode with a change of circumstances. Many of us say this is very unfair. Whether that can be challenged by judicial review, we'll have to wait and see. The other nasty bit of this, I'm afraid, is that your transitional protection, if you want to call it that, is subject to termination. Going down the left-hand side are circumstances which could lead to the death of your transitional element. Notice that includes relationship changes. This, to my mind, is extremely cruel. I deal with lots of people. I deal with Macmillan quite a lot, and people who are going through loss of partners for reasons connected with health. It just seems to me very, very wrong that you could lose a partner under those circumstances, but then lose all your transitional protection, all your element. You can also lose if you lose your job, if you lose universal credit, or if your income goes down by a certain amount. On the other hand, you would keep it. You don't lose it because you lose your PIP or DLA, or a non-dependent moves in. There are some circumstances which are far more hopeful on the right-hand side there, where you can keep the protection, but on the left-hand side are very worrying issues. And I'm afraid the problem with this is no one's telling anybody. Clients are not being told that these things can happen. And that's really why I'm talking to you today, I suppose. Baroness Sherlock, you probably didn't think you'd be getting Baroness Sherlock today, but Baroness Sherlock made a speech in the House of Lords a little while ago, commenting on the amount of compensation that's being paid to people, especially since the 27th of January this year. And it's just true that the compensation that you get, which is through the SDP element, which boosts up your maximum amount, is not sufficient to cover all of your costs. I'm sort of doubtful if the courts will ever agree that's a bad thing, because we've had a go at that already, going to the High Court. What all this does come down to, as we head towards the end of this little presentation, is the business of whether your client should stick or twist. Should they stay where they are on legacy, or should they twist onto universal credit? These are very difficult areas that sort of thing is what we explore on the training course we've developed. clients who are disabled or going to become disabled. Certainly self-employed people where legacy is much kinder than universal credit. People with disabled children may be better off staying as they are. On the other hand, if you're sick but not disabled, jumping ship may be a good idea. If you've got a working carer, that could be a good idea. These things are things that need to be explored, and we need to work through these problems with clients so that they don't make rash decisions. That's, I think, where we're kind of going with that. Certainly in relation to the benefit cap, we see that all of these things, there are impacts on all of this that need to be taken into account. Because we've run out of time, I've only got very little to show you now, but just in case we do run out of time, just to say, as a separate issue to what I was just going on about, although related, if you've got any clients who've received extra money because of the COVID uplift, the extra £1,000 a year, do be aware that that extra money counts for the benefit cap. So you might come across people who've been given the money but then lose it because of the benefit caps applying. Lone parents are a chief target for this because it's lone parents, couples with children who are mainly being benefit capped. There's not much you can do about that, I'm afraid, apart from seeing whether the person can get an exemption from the cap. I just thought I'd mention that because I've only got time for a few more slides and then we stop. I wanted to finish off simply by saying that if you want to plead, if you want to talk about whether someone should naturally migrate or not, whether it's a good idea or not, I've put into your e-learning pack document L a natural migration checklist for you to use to try and help a client understand whether to jump ship or not. Have a look at that. If you like it, use it. Let me know what you think. If you change it, send me a copy at CPAG JR. I'd love to get it. If you've improved it, I'll give you the credit for it and we'll use it in the future. So it's just an idea for you. And the very final thing, and then I'm going to shut up and release you back into the world. To finish off is just to say there is a way of proposing complex needs. I'm going to do 2 more slides and then I'm going to leave you in peace. You could just send a memo. You could put a note on a journal. I'm suggesting a better way for you. I'm suggesting that you think about, to finish off, a complex needs request in writing, a 2-page document. The request says who you are, your address, and sets out what your complex needs are. Then on page 2, down the left-hand side, it sets out what the conditionality, the mooted conditionality is. And on the right-hand side, I've set out how I'd like to see it changed. Whatever you do, I think it's worthwhile drafting these documents and submitting them to the DWP to formally notify what the complex needs of your client are. If you can use regulations and case law, all the better. You'll see in that clip there, I've included a reference to Regulation 95. We looked at that earlier. I'd like you to fill up these documents with references to regulations and case law. Because if the DWP doesn't agree with this and it comes down to a tribunal, you can use that document with the judge to argue that the complex needs have been effectively ignored. And with that, my colleagues, that takes us to 12:30. I don't know whether you're still with me, whether you've fainted. I don't know whether that was all too much for you. Those slides are all, the latest version, I'll make sure they get through to Joe and that you'll get a full version of those, plus all the other documents that have been coming in. I hope that was of some use. I'm afraid I've left, I did ask you a few times if you had any questions, but if you've got anything and you want to ask me, you can do it now if you want to, or you can send me a message. I'm happy to engage with you within the next 7 days on any questions about today's presentation, just to make sure it's all square for you. But apart from that, Joe, I think I'm done.
Yes, I was just coming back and to say a big thank you. That was really interesting, and yeah, it's really great to have you on board today to cover all of that. I just wanted to add a very, very quick note at the end that this session, the recording of the session will be available online, so we'll be notifying all of the attendees, all of you, when it's up, so you can come back and check it out again. And yeah, like Steve said, if you've got any extra questions, you can pass them on to us if you want, or just contact him. But otherwise, thank you very much, Steve, and thank you
That's
very much
great.
for everyone attending.
I'm going to ring off, so I know that you've got your time limited on stuff. So we'll leave it like that. All I want to say is hope that was okay for you, and I hope you have a really nice weekend, everybody. Take care now. I'm going to say goodbye. Bye, Joe.
Bye. Thanks, everyone.
Bye, everybody.
Cheers, Steve.